Good afternoon. It is March 30, 2020. It's feeling like the Twilight Zone. I'm here in a rented house so that I can be quarantined. Mike Markham is at his home. He's quarantined. And we're going to talk today about something that is going to be very important to hundreds of thousands, if not millions of individuals and businesses in the United States. And that's how bankruptcy and debtor-creditor law impacts the virus situation, and in particular, what the biggest mistakes are that people and advisors will be making in helping and trying to help clients at the present time. So Mike, thank you very much for joining us for this presentation.
Thanks, Alan. As you can imagine, I've already been bombarded with calls from panicked people, whether they have a restaurant, a bar, as you know, Alan, medical practices where all the non-essential services are shut down. So all of the, eye doctors, dentists, chiropractors, podiatrists, surgery centers, they all currently have zero revenue. But as we know, they have expenses. And so the questions I've got, look, I have no revenue. Is there a bankruptcy option for me? So I've hit them with, look, there's always a bankruptcy option, but the question is which one and when. If you're going a Chapter 11 reorganization route, revenue is an important part of that. That's what bankruptcy plans are about. You've got to propose a plan. You've got to project your revenue and expenses. And if you think it's difficult to project revenue in a normal environment for a distressed business, think about projecting revenue in this environment where you don't even know when you're going to reopen again. So I think the biggest problem businesses have now is they don't even know when they're going to reopen. They don't know how bad it's going to be. And so with that being the case, I have to tell them, you got to wait. You got to wait as long as you can, because you can't file Chapter 11 with no revenue unless you're prepared to put money in. And if you're prepared to put money in, great. And we'll talk about that at some point today as well. So if the basic bankruptcy differences, Chapter 11, a reorganization chapter, Chapter 7 is a liquidation chapter. If you're going to liquidate because your business just isn't going to make it, then you're in no rush to do that. It doesn't matter if you file bankruptcy, doesn't matter when you do that. That's not a big deal. The bigger question is, how are you going to survive long term if you want to survive long term? So let's talk about really what's probably the most important thing is, okay, I want to put some money in. What should I put money in for? What should I pay? What should I not pay? Right now, you're in absolute crisis mode. It's not your fault you're in crisis mode. And I'm pretty much telling people, you should only pay what you absolutely have to pay. So they go, all right, so I've got to pay my mortgage, right? And I'm like, no, I'm not sure you should pay your mortgage. What about my rent? Should I pay my rent? No, I'm not sure you should pay your rent, particularly on a business level. Personal, it might get a little different, but on a business level, I've already heard stories. I've already heard from my real estate clients who have tenants like Starbucks or Dentist Off, Aspen Dental, fast food restaurants. Their clients have already told them, their tenants have already told them, I'm not paying you. So they've already communicated that up the line to their lenders, and their lenders are already trying to figure out. So everybody knows this is coming, and nobody expects, I don't think, businesses to pay rent or mortgage, occupancy cost, which is always one of a business's greatest line items in their budget. I don't think they expect it to be paid. So then the next question is, well, What if I don't pay? I mean, what's going to happen? Well, fortunately, in Florida, foreclosure is judicial, so it's going to take time. We don't have a moratorium on foreclosures and evictions yet, but I think we are going to have one. And even if we don't have one, we effectively have one because the court systems are almost shut down. All hearings are being done telephonically. Nobody's appearing in person anymore. I don't know how much longer the courts are going to stay open where employees are actually going to be going to work every day. So it's going to be very difficult with a foreclosure, even in a normal environment. Foreclosure is usually a minimum 6 months before there's real pressure on you. You can file bankruptcy right up until the day before the foreclosure sale. So that's plenty of time to at least see how this crisis pans out. On the eviction side, the window is a little bit shorter if your landlord is pushing hard to get you out, which I don't know whether landlords are going to be doing that or not. Your landlord, you might have a landlord that wants you out for other reasons. You might have a landlord that just wants everybody out. Who knows? Most landlords, it's income producing property and they want people that are going to pay. But even still, it's judicial. They have to file an eviction action. They have to serve you with it. They have to give you a minimum of 5 days to respond. And then once you respond, they have to have a court hearing. And so even an eviction takes a minimum of 30 to 60 days. And in the current environment, might take a lot longer. So evictions are certainly a little tighter and you might have to file. That might be a pressure point that causes you to file earlier. But that's a pressure point that you can deal with when the time comes. The cash that you have is going to be precious. You're going to be out of it soon. Then you're going to be thinking about coming out of your own pocket. People are asking me, what about utilities? What about that kind of stuff? What about taxes? Well, taxes, I got to say, I don't think the government's going to be the bad guy in all this. I know that the Pinellas County tax collector just extended the payoff deadline only for a couple of weeks, which was odd to me, but the normal deadline is March 31. For real estate taxes, they extended it to April 15th. I expect to see further extensions of that, but still, you don't pay real estate taxes. They go to a tax certificate. Big deal. They go to a tax certificate. Most of those get bid out. You end up paying 0.25% interest, which is a heck of a lot less than the 18% that you would owe the tax collector. If the tax collector didn't sell the certificate, then the certificate can't go to tax deed sale for 2 whole years. So paying real estate taxes or tangible taxes makes no sense right now. Other kind of taxes, federal taxes, I'm never going to tell anybody not to pay them, but you got to pick you got to pick what's really, really important. Utilities, I'd be communicating with the utility company to find out if they're really going to shut me off. For that matter, if there's nobody at your office and you don't deal with perishable items, does it matter that you have utilities if you've gone remote during this shutdown? So you got to think about each one of those, and you got to each check you're about to write. I think you got to think about it. So then the next point,
Mike,
sure.
Let me just mention before you go to the next point. State law will differ. We do have a lot of attendees outside of Florida, so state law will differ. But in most states, if not all states, there does have to be a foreclosure, or there has to be a lease eviction. The amount of time it takes can vary. A couple of considerations, and I know you take them into consideration in your white paper here, is if you miss a payment and you don't correct it, you could get booted out of your lease. If you have an under fair market value lease or a nasty landlord, when this thing clears up, do you think there will be federal or state legislation that will allow tenants who violated their lease to stay in nevertheless? Or do you think landlords might be bullies and kick people out and take over businesses and things like that?
Certainly, if you default on a lease the landlord has the right to terminate the lease. If the landlord terminates the lease and you file bankruptcy afterwards, then you don't have any lease to assume. So certainly if you think your landlord is hot to get you out for some reason, that is an important consideration. Flipping that over to the lender side, Alan, an important consideration is, all right, I don't pay my mortgage or I don't make my loan payment, and they declare a default, and then they trigger default interest. I would be wanting to know what that default interest is. Some loan documents say maximum rate allowed by law, which in a lot of states is 18 or 25%. So you could have your loan go from 5% to 25%. I just had a conversation with a client last week where thankfully their loan documents, the default rate was only 4 percentage points above the contract rate. So maybe it went from 5% to 9%. That's not the end of the world, right? But 25% interest to be accruing is not good. And bankruptcy, once they've declared the default and they're entitled to default interest under state law, that is something that under bankruptcy law they would also be entitled to. To your question of will the government do something, I suspect they will, but we just don't know that right now. There's been talk of moratoriums and other things, but I got to believe that the government at some point is going to have to do something in the banking world, and there's going to be some bartering going on, and part of that is going to be not, bullying your borrowers or bullying your tenants.
So another quick question. I know there's something in the Bankruptcy Code about filing bankruptcy and only having responsibility for up to 1 year in a long-term lease. So how would that work if I have a 10-year lease and I don't think my business is going to survive? I personally guaranteed that lease. Is there a get-out-of-jail-free card in the Bankruptcy Code that allows me to file bankruptcy and limit my exposure to 1 year?
Well, the Bankruptcy Code has a special provision that if a lease is rejected, leases must be either assumed or rejected. If a lease is assumed, then all the defaults have to be cured. The courts, I think, are going to be a lot more liberal about the length of that cure period on an assumption. Generally and historically, that's been, call it 6 to 12 months. You might see courts give much longer cure periods, because if you miss 6 months of rent and they only give you 6 months to cure, that means you're making double rent, right? And most businesses can't afford double rent. If you reject, that means you've got to surrender the premises, and then that triggers the provision that essentially caps the claim at 1 year's rent. So that at least caps that claim, and you see that used a lot in retail bankruptcy cases. And when you have the big retail bankruptcies, that's the primary reason that they're filing, and you see them reject leases almost on day one of the case. But interestingly, that if the individual guarantor files bankruptcy, that 1 year cap, at least in Florida, at least under the controlling law in Florida bankruptcy cases, is that the 1 year cap also applies to a guarantor that files bankruptcy. However, the 1 year cap does not apply to a guarantor that's not in bankruptcy. So if the business craters, the lease is rejected while the bankruptcy claim is capped at 1 year, that non-bankrupt guarantor is going to get sued for the total damages under state law.
So that guarantor would also have to go into bankruptcy and would have some sort of plan approved that would limit the liability to a year?
Yeah, if they went into a reorganization type bankruptcy, either a Chapter 11 or a Chapter 13, then yeah, they would have to, that claim would be capped out at 1 year. If the person was able to file a Chapter 7 liquidation bankruptcy, kind of doesn't matter how big the claim is, because that pretty much means that there aren't a lot of assets in the bankruptcy in the first place.
Okay, thanks, Mike. And before we go on, I should have said in the beginning of this presentation don't try this at home. If you're not an experienced bankruptcy lawyer, I don't care how many books you've read and how many conferences you've gone to, you need somebody like a Mike Markham to help you guide these clients. It's fine to get all the client's information, to tell the client what you know, to tell the client your opinion. But if you're doing this without an experienced bankruptcy lawyer assisting you, you are treading on very dangerous waters. So Mike, what is our next topic here?
I think the next topic, Alan, is putting money in. I've already gotten these calls this week, and people are like, look, I'm running out of money, or I'm out of money. I want to pay my employees. I want to make payroll because they want to do what's right by their employees. Maybe they have a couple of critical vendors they want to take care of. For whatever reason, they've decided they're going to put money in. If you're going to put money in this environment, you need to put it in, you need to properly document it, and you need to properly secure it. Meaning you need a written note, a written security agreement, and you need to file a UCC financing statement to properly perfect the lien against the company's assets, so that later on down the road, if you end up in either a liquidation mode or a Chapter 11 reorganization mode, that you're the first person to get your money back out. Otherwise, if you put the money in and you don't contemporaneously secure it, then if you pay yourself back, that's going to be what's generally called an insider preference, and it has a 1-year look back. So if you put $100,000 in this month, and 3 months from now you pay yourself that $100,000 back, and God forbid 6 months later the business fails anyway because it just couldn't survive, then you're at risk of getting sued for the $100,000 that you took back out. If you put it in and it's secured and you take it back out as the secured lender, you do not have that preference exposure. So on that point, Alan, the next question I got asked was, what about the $300,000 I already put in last year? Can I secure that? Because they just now heard, oh my gosh, I should have secured that. You have a similar problem. If you put in money last year and you now secure it, then that lien that you're taking on the company's assets, that can be a preferential transfer. So if you secure a lien now, that lien is going to be avoidable as an insider preference for a 1-year period of time. So if you secure a lien on pre-existing debt now and you file bankruptcy within a year, you're going to lose that lien. So just to understand that that's not necessarily going to work. I think if you're going to be putting money in now contemporaneously, I would limit my lien to that new contemporaneous money so that I didn't look like an overreaching, business owner that was trying to gain an advantage, on my creditors.
Mike, a lot of professionals are advised to take a salary of about $280,000 a year and to take the rest in dividends, and they take it every month, and that's to keep employment taxes down. I would think that right now you would continue to take your regular salary, but not take any dividends, because dividends would also be considered a preferential transfer that would be set aside within a year, correct?
Yeah, well, dividends would probably get set aside as fraudulent transfers, meaning, distributions from an insolvent entity. There's nothing wrong with you taking your regular salary right now. That's perfectly normal. But you shouldn't be looking at taking distributions out. And if you're lucky enough to be in a business that lets you do that, you're probably not worried about filing bankruptcy anyway.
So under the preferential transfer rules, if I'm owed $20,000 in back pay because I didn't get paid in February, and I now take and I'm owed $20,000 this month for my work this month, and I take $20,000. If I'm taking it for the February work, then the 1-year rule applies. But if I'm taking it for the March work, then the then that set-aside rule does not apply. How do you record keep? How do you designate? How do you make sure that this contemporaneous payment for value will hold up?
Well, you just need to document it as best you can. You know, if you're going to make a paycheck, make it for the current pay period. Don't make it for the past pay period. On payroll, Alan, it's a little bit different analysis than an ordinary debt because employees do have a priority claim in bankruptcy up to approximately 13,000. So if you were taking 13,000 only on past, as long as it was within 90 days, then that would be priority and it probably wouldn't be preferential. If you're taking more than that, it would. But if you only have the 120,000 that you can pay that 20,000 for the current pay period, document it as such, and leave the old 20,000 on the books, you know, as a debt, you know, loan, debt to shareholder, whatever, however you would call it in your books.
Okay, very good.
So let's talk a bit, Alan, about some changes to the Bankruptcy Code and then some even more changes that just happened with the coronavirus bill. Very recently, the Bankruptcy Code was modified to include a special small business chapter, or at least a very modified small business chapter within Chapter 11. In that new small business chapter, it applied to small businesses, meaning businesses whose debts do not exceed about 2.7 million. And then the advantages of that small business subchapter, as they call it, were that it moves faster. The unsecured creditors don't vote on a plan, so you don't have to solicit ballots and acceptances of your plan to unsecured creditors. And you don't have to file reports and pay fees to the Office of the United States Trustee. Instead, what they do is they're appointing this subchapter 5 trustee who's really kind of a mediator of sorts that gets involved in your case and helps you mediate with your creditors and get your plan pushed through. And it's supposed to happen very quickly. It's supposed to be about a 60 to 90 day process. So that had just gone on the books. And frankly, I haven't even seen, it's been on the books so few weeks, I haven't even seen how it's worked in practice. And so then I learned that in the disaster bill that was just passed last week, that part of what they did was they raised the $2.7 million cap to $7.5 million. So you could have total debt of, you know, $7 million, which is a significant amount of debt for a small business. And you're still eligible for that more fast-tracked, less invasive, you know, small business chapter. So I suspect that the cap's only been changed for 1 year because they're expecting this to be over within a year. I wouldn't be surprised if they extend that because they're going to see how great it worked, but we'll see when we get there. But you know, it's always been very difficult to take a client that has 3 or 4 million in debt and run them through a normal Chapter 11 process, because Chapter 11 is a lot of paper, very time consuming, very expensive. And this subchapter S thing was, or subchapter 5 is what they call it within Chapter 11, was supposed to cut down on that expense and make this you know, a little easier on those smaller businesses. So we'll see what happens, but I think you're going to see a lot of those. And oh, by the way, that small business chapter applies to individuals as well as businesses. So you could have an individual with up to $7.5 million in debt that's now eligible for what is in essence a super, you know, Chapter 13, where the plan payments are really driven by the person's net disposable income. So, and creditors don't get to vote. So, Alan, we've talked about this before, but in individual Chapter 11s, the problem in the past had always been that if you didn't get the vote of your unsecured creditors, you were kind of at the end of the road because of what's called the absolute priority rule. Now, under this small business chapter, since your creditors don't vote, all the court's going to do is look at your projections of revenue and expenses. And as long as you're paying your net disposable income to your creditors, I mean, that might be 1 or 2% on the dollar. I mean, think about it. If you have $7 million in unsecured debt, even if you had $100,000 of net disposable income per year for 5 years, that's 500,000 on 7 million. That's a small fraction. So this is going to give some individuals, a real opportunity to maybe clear out some stuff.
Now, what about the secured creditors? They'll still be able to vote, and we'll have to approve a plan?
Yeah, you'll still have to work through with your secured creditors. But again, if you have a secured creditor, the only issue with a secured creditor is the value of their collateral, right? Well, look at the opportunity that's going to bring you now. There's no question that 3 months, 6 months from now, and I'm purely estimating, right, based on the length of this crisis, but right now, collateral values, whether that's real estate, equipment, inventory, receivables, what's happening? The value's dropping rapidly. Your receivables, you could have $1 million of receivables on the books. Well, nobody's going to pay them. And you're going to wake up 6 months from now and everything's going to be 180 plus. How do you value 180 plus receivable? Generally 10%, 20% max. So what's happening is the value of secured creditor collateral is dropping. So that means you're going to, that's generally what you have to pay them. The value of their collateral is what they get, stripped down to through the valuation process. So you're going to see a lot of collateral. Maybe it gets devalued over this next 6 to 9 months, but it ends up being actually worth more than at the moment you value it. The general rule is that you value collateral for purposes of bankruptcy on the petition date, and you don't consider increases in value during the case. So if you file, I always tell people, there's a trough, right? It comes down and then you go back up. And I always tell them, wait till you get to the bottom, and the second you see that first little uptick, that's when you file. Because then you're going to have income that you can make payments with, but that's also going to be the low point in the valuation of collateral.
Wow, very interesting. So even if the secured creditor is not cooperative, as long as the plan provides for the secured creditor to get their value back based upon the date of the value of the collateral on the date of filing, then the judge will approve a reasonable plan?
That's generally the rule. I mean, obviously there's a devil in the details, as they say, on that stuff, but I've got to believe bankruptcy judges tend to be pretty debtor friendly. And I think this crisis is going to make them even more so, because this crisis is nobody's fault. It just happened. So no different than when you see, I can tell you, I couldn't count the number of times I heard a few years ago, well, the business was really impacted by Hurricane Irma. Any kind of disaster, bankruptcy judges tend to give the benefit of the doubt to the debtor, and debtors tend to get treated probably more fairly from their perspective, certainly, than creditors feel like they're getting treated. So we'll see how
that's good. Yeah.
We'll see how much the bankruptcy world gets.
Super. What do you have next for us?
Well, I haven't done a very good job of scanning down through the white paper, as you mentioned it, but a couple of things. A lot of people are wondering, look, is there anything I can do, especially the doctors with businesses, like they're an eye doctor. All they do is cataracts and LASIK. And they do a ton of it, Alan. We have these clients, them. It's high volume, big money, private pay or private insurance pay, or even Medicare on cataracts by return mail, and they're out of business. The government has said, no, you're non-essential. You've got to shut down. And I had a client ask me, will bankruptcy help me get around that? Unfortunately, no. Bankruptcy's not going to undo any of that stuff. What's going on right now is the exercise of police powers, and police powers are generally accepted from the Bankruptcy Code, and bankruptcy courts can't do anything to impact, a state or federal government's police powers. So you can't file bankruptcy next week and get yourself operating again out from under a state or local moratorium that's on the books. You're just going to have to wait it out. But I got to believe that as soon as it's possible to let those things reopen, they're going to reopen them depending on, the situation. So what have I been telling people to do? I mean, a lot of people they call, they're panicked. They don't know what to do. I kind of give them the same speech that I give my panicked clients every time. This is like an 8th grade math test. If you sit down in your 8th grade math test and you read the first question and it really stumps you and you panic, I can tell you what grade you're going to get. You're going to get an F because you've lost focus. You don't know, oh my God, I can't figure this out. I can't, you can't get that way. This is the time where you've got to get even better at managing your own emotions and your own mind. And you've got to skip that question. You've got to roll your sleeves up. You've got to go to question number 2. And you've got to all right, I got question number 2. I got the answer for that one. And write that stuff down. And really, this is a time to build new discipline, new focus, and not to panic, because if you do, I can tell you the outcome. And so, I got nothing going on. I got nothing to do. I can't buy anything. I can't sell anything. I don't have any employees. I said, look, start thinking about your business as a whole. Start self-analyzing your business. Look back. Was this a part of my business that was really profitable? Because now's the time to do a full reset, right? You can do a full reset on your business. Let's say you had 4 business divisions that, 4 things you made money on, and one of them you didn't really make money on. Now's the time to cut it loose. Now it makes perfectly good sense. I'm going to cut that part of the business loose and blame it on coronavirus, whatever. But now's your time to reset, start over. Maybe you start with an even more profitable business and start thinking about, what's my most profitable business? Who are my most valued employees? Start cutting stuff, because now's the time where you have to do it. And you figure out, when you have a business that's 5, 10, 15, 20 years old, it's no different than your house. You start opening closets and going, why do I have all of this stuff? Treat your business the same way. Start clear out what you can, get yourself reorganized, reset the button, and start thinking about the minute this thing opens, how am I going to make $1? How am I going to do my best on the day it opens? And if you're ready when it hits, you'll be ready when it hits. If they reopen tomorrow, they're not going to do that, but at some day they're going to reopen. You need to be the guy that jumps out of the starting blocks the fastest and grabs that market share back that nobody's had for all those months. So that's what I would tell you if you're in that panic.
And as we've seen, Mike, from years and hours of conference time, when you meet with a client, if you listen to them and you help them hear themselves, it allows them to have a sounding board with their CPA, with their lawyer, with their friend, with their banker, and with a good bankruptcy lawyer. A lot of decisions can be made in the conference room that will be much better than the decisions that people have made on their own without getting help. Part of that is the psychological process that we go through. We shut down. We're deers in the tracks. We think we know all our alternatives, but we really haven't checked all the alternatives. And one thing I really liked about your white paper, Mike, I think at least 3 or 4 different times, you said, number 1 is your health. Number 2 is the health of your family. Number 3 is your business. Because as you've also said many times to clients, when the oxygen masks come down on the airplane, put yours on first, because you can't save everybody else until you're secure. You can't have a business that employs 20 people if you keep all 20 people on the payroll and there's no money left when it's time to reopen. You're better off with 2 employees and 18 that'll hopefully come back, right?
That's right, Alan. And a lot of business owners they'll be thinking right now, they have one $20,000 check they can write, or they have X dollars in the bank account. They've got to use it for something, and they're struggling with, should I pay myself or should I pay these other people? And again, like the mask that's fallen, I tell people all the time also, don't violate rule number 1. Rule number 1 is to look out for yourself, because there's nobody else looking out for you. And if you look out for yourself and you keep that business open and operating, then those people will get their jobs back, and they'll be long-term jobs. They won't just be one more paycheck. We're not talking about one more paycheck. None of this is about one more paycheck. We're going to get through this. We're going to wake up one day and we're going to be through it, and we're going to be talking about, oh my God, that was terrible. We're going to be talking about this for the rest of our lives. The pandemic of 2020, the coronavirus, whatever we call it, we're going to be talking about it. But hopefully people then are going to use this as a way to be better for the next time. But yeah, you got to look out for yourself. In every dollar, every check you write, you've got to ask yourself, is this going in the right direction? Is this a check I need to write? Particularly now when we don't really know the end, the end of the crisis. That's the part that makes this the most complicated thing to deal with. And on that point, Alan, here's something both at the business level and at the personal level that I would encourage people to do. Sit down and make a budget. And people go, oh yeah, I do that all the time. I go, well, show it to me. Well, no, I do it. I have a budget. I'm telling you, I have a budget. I go, no, I mean, is it on paper? Is it on a piece of paper? Is it in a spreadsheet? Is it written down? I don't care if it's on lined paper from elementary school. I don't care, but I'm telling you that the average person, both at the business, well, I have a P&L. Okay, let me get you my P&L. I hate to tell you, but those P&Ls that come out of that QuickBooks, they're worthless to me as a bankruptcy lawyer that's a cash manager. I'm in cash management mode. I know there's X dollars coming in, and I need to make sure there's not X plus 1 going out. So sit down, business level, personal level, make a budget. Look back at your checkbook. Look at every single check you wrote. And don't forget about the quarterly and the semi-annual and the annual payments you make. Don't forget about, oh, I only pay my real estate taxes once a year. Well, divide that by 12. Don't forget that you only pay your car insurance twice a year. Well, divide that by 6. Put it on the budget. You'd be surprised how many people are running at a negative and don't even know it. And so I would challenge everyone, use this time, get that budget down, figure out that you're paying $211 a month for Sirius satellite radio. Figure out that you're paying $284 for cable and internet. Figure out these little things that you're paying for and ask yourself, now's the time to pare that stuff down, get lean and mean, change. This is like going on a diet. You need to make permanent changes. It's not, the diet's the opposite. If you take in more calories than you burn, you gain weight. If you take in less calories than you burn, you lose weight. The budget's the same way. If you spend more than you make, you're getting deeper in the hole. And people don't even know they're doing that. Spend time on the business level. If you sell something in a manufacturing or even an assembled good type item, I'm always surprised that clients don't know their cost of goods sold. And they're doing, Alan, what we call in the business, making it up on volume. They're losing 48 cents a unit, and they're happy that they sold 600,000 units last month. Times 48 cents, they don't even realize they're losing money. They're excited about those sales. If you're selling something you're losing money on, you're not making money, you're losing money. So now's the time to get out that pencil and sharpen it and figure out some of those details that you just don't have time to focus on, when you're so busy because you're running your business.
Let me also mention, Mike, you and I have seen time and time again where people took the money from their IRAs, which would have been creditor proof. They paid tax on it, which Congress just said you can do that to the extent of $100,000. They pulled on their home line of credit, losing the ability to protect their homestead. And they've done these things while keeping their boat and their vacation home, because the boat went down in value, the vacation home went down in value, and they're waiting for them to come back up before they unload them. Sell the boat as soon as you can. Sell the vacation home as soon as you can or leverage them before you have to touch your home equity loan if you're a Floridian, or your IRA. These are your safe assets. You're going to need them to restart.
Yep, no question, Alan. If somebody came to me right now and said, should I take out a mortgage on my house to keep my business afloat, I would probably say the business that currently is closed, that business. And I'd be sarcastic because I'd want to get their attention and I'd want them to think about it. But I will tell you that until I know the end of the story, until I can see light at the end of the tunnel, right now there's no light at the end of this tunnel. I don't know if it's April, May, June, July, August, or September. I don't know. So now, if I see light, and I know that if I go get 200 grand, I can solve my problems and I can be ready to go in 2021, whole different issue. Maybe then I could get more comfortable. But right now, the idea of leveraging or liquidating exempt assets like homestead, retirement assets, cash value of life insurance, and I'm talking Florida exemptions, obviously, Alan, not national or federal. But again, I would not leverage or liquidate any of that stuff right now because I don't know the end. But you're right, I would be not, the first payment I wouldn't make is the boat payment. The next payment's on the vacation home. The next is on all my toys. You can always get toys back, when you're doing good again. Let that stuff go. That's the last thing. So this is an opportunity for, decluttering. But yeah, I would not be thinking about leveraging exempt assets right now. I think that's very short-sighted.
Absolutely. Okay, anything else? That was a really, really good white paper, a very good presentation.
No, I don't think so, Alan. I think we're in for a pretty long haul here, and I think that's what's important is for people. Unfortunately, right now you're just living day by day, week by week, until there's some indication that we're heading back to normalcy. But I think when we get back there, I think there's going to be a lot of pent-up demand, and I think people that are ready to move forward with their businesses are going to be in a great position.
There was one more thing in your white paper, which basically was you need to have at least $25,000 set aside to pay for a Chapter 11 bankruptcy. I know based on size and complexity, it can be multiple times that, but that would be your last powder. So you really have to talk to somebody like Mike, see how much to put aside to pay for a bankruptcy, and make that, eat Spam instead of steak and chicken to the extent you need to make sure that you can pay for bankruptcy representation when you need it. We know from experience that makes the difference between survival and thriving or closing it down and getting a job.
And thanks, Alan, for that. And obviously those numbers can change depending on circumstances, but also you're sitting there right now thinking, my client doesn't need to talk to a bankruptcy lawyer, or I don't, or I don't need to talk to a bankruptcy lawyer. You need to be thinking about, well, am I going to need to be talking to one in 2 months or 3 months or 4 months? because if that's out there, you should go ahead and talk to that person now. Because
Right.
it may be that there are things that you could be doing now, that make more sense than waiting. The waiting, particularly waiting to the last minute. And I can tell you, in my world, people usually get to me much later than they needed to get to me. So it never can hurt to have that consultation, 1 or 2 hours, go through some basic questions, get some basic understanding, and then know, all right, if this happens, that's when I know I really need to engage this person proactively to try to stop whatever bad thing is about to happen.
Beautiful. Okay, Mike, thank you very much. We'll be calling on you again. Thanks for everything you've done for our law firm and for our clients over the years. Unfortunately, I think there's going to be a lot more of that in the next 3 to 5 years. This thing is just going to be unfolding and unfolding for a long time.
Well, thanks for having me, Alan. I look forward to doing it again sometime.
All right. Stay healthy. And thanks to all the listeners and viewers today. May the rest of your time be billable.